Thank you, Mr. Chair. Good morning, ladies and gentlemen. My presentation title is the Intellectual Enforcement in China, Mechanism, Situation and Consideration. And as everybody knows, TRIPS agreement has contrasted IP dispute resolution mechanism consists of civil, criminal, and administrative procedures. The agreement requires that members should ensure the enforcement procedures mentioned in it be available and the national laws. Since the entry of WTO in 2001, China has perfectly performed the obligations regarding IP enforcement set by the TRIPS. So, my presentation, the first part is the mechanism in China in the field of IP enforcement. The IP system in China was mainly established in 1980s. During 1990s, great progress had been made to the IP system. As an important part of the IP system, enforcement and dispute resolution mechanism has been built as other aspects of the system. Laws related with the subject, civil law, civil procedure law, criminal procedure law, and IP laws, and the rules including patent, trademark, copyright, and fair competition and plant varieties. In China, these are mainly two channels for IP owners choose to settle the infringement disputes: administration and judicial trial. So first, I would like to introduce administration enforcement. So the administrative enforcement to protect IP right is one of efficient IP enforcement methods, as one kind of alternative dispute resolution, ADR, which has been realized in many countries. Its special features of simple procedure, short time, and less payment make the authorities play special roles in handling disputes and protecting IP rights. This way includes two aspects: mediation and assumption. The duties of dealing with different kinds of IP disputes are held by various branches. There are various authorities involved in this area, named as IP administrations, the SAIC and its local branches, the State Bureau of Copyright and its local branches, and the custom administrations. Whereas IP infringement occurs, the IP owner has the right to decide whether to before an administrative authority or bring a civil lawsuit to a court, except in case of serious infringement that a crime is committed, which should be prosecuted by the public prosecutor. When dealing with the case, the authority mediates between the parties on the basis of identified facts and urge the parties to settle down the dispute by an agreement. Even in this sanction case, the authority may mediate between parties as to the amount of damages, if required by the parties. This means that the authorities can't make decisions on the mediation. In comparison with other countries, the scope of customs protection of IP rights in China is broader than that of many countries. First, the Chinese customs may take protective measures in respect of both import and export goods, while many countries and regions generally will not take any measures regarding export goods. Second, the customs protective measures are equal for utility model as well as for patents, trademarks, and copyright. Whereas there is an allegation filed to an administrative authority, the authorities shall initiate the procedure of investigation, including collecting evidence, determine what factual judging, whether infringement exists, and finally make a decision, and the relevant provisions of laws and rules. If either of the parties to the dispute is not satisfied with the decision, he may take a lawsuit against the authority to a court before the expiration of the provided period. Generally, it's about 3 months. The court would try the case and make judgment. For example, in case of infringement, the patentees or persons whose right and interest are influenced by infringement may request a local IP office to deal with the matter, or may directly bring suit in court at where the defendant resides or infringement occurs. Upon the request of the patentees or persons whose rights and interests influenced by infringement, the administrating and verifying evidence, the authority usually mediates between the parties at first, and ascertain set to end the dispute by an agreement by which either the defendant would agree to stop infringement or pay compensation to the patentee, or the patentee would agree to grant a license to the defendant. If no agreement resulted, the authority should, upon clarified facts and evidence and by applying pertinent laws and rules to the case, make a damages. If any party dissatisfies with the decision, they may institute legal proceedings in the People's Court that has the jurisdiction of the case within 3 months from the receipt of the notification. If such proceedings are not instituted within the time limit, and if the order is not complied with, the office may approach the People's Court for compulsory execution. The court then accepts the lawsuit would review the decision made by the office. The result of such judicial review may be, first, affirming the decision of there is no mistake related to evidences, facts, and the laws applying. Second, revoking wholly or partly the official decision, and or requiring the office to rehear the case if the evidence are not sufficient to support the decision, or the rules applied to the case are incorrect, or there exists contradiction to legal procedures. The authority has abused its executive power. If the defendant commits infringement, the authority has power to order him to stop infringement. I think it's a kind of efficient injunction. Pay damages to the owner or administrative sanction. Order him to pay a fine, seize the infringement products, equipment used for infringement. So the second part is judicial trial, and I think this way is similar to many countries. So for saving time, I will save this part because time limits. Okay, you can find this material in the introductions material. And the second part is the situation. Recently, Chinese government attached great importance to the IP enforcement. The status and the role of IP had been enhanced to a historic height, and great improvement was achieved in the IP enforcement in China. In 2006, 3 kinds of patent applications accepted by the State Intellectual Property Office, my office, amounted to more than this number I will say. You can look at it material. And no, it's the number 3 in the world. And also the trademark application in China is number 1 in the world. And a lot of transnational corporations and applied for patents and trademarks in China. This tells us that most of the corporations believe in the protection of IPR in China. So the President Hu Jintao, in the last year, in July, he required to perfect IP protection and enforcement in China. And in the same year, Premier Wen Jiabao pointed out in his speech, to protect IPR is to respect knowledge, encourage innovation, and protect productivity. He also stressed China should strengthen enforcement, administrative supervision, international cooperation, and education for all to form a relatively complete IP protection system. Premier Wen Jiabao delivered a speech at China-EU Industry and Commerce Summit 2006 on September, entitled Insisting on Mutual Benefit and Win-Win, Strengthening Cooperation and Innovation. It pointed out protecting IP is not only the need of fulfilling the international obligations, but also the need of China's own development and the need of improving the capability of independent innovation. China's attitude towards IP protection is clear, and the commitment is firm. So since 2004, the government has established the following IP protection principles and required relevant organizations in China to abide, keeping promise, corresponding to national conditions, consummating regulations, and protecting IP actively. So the number I will save in the following. The last part I will give my consideration. Firstly, I think efficient enforcement is essential to IP systems. As we know, the modern technology develops so fast and a knowledge-based economy has already appeared. How great changes have happened in the latest 200 years. So I think the IP system, especially the mechanism concerning the enforcement, has changed a little in these 200 years. After all, the field development of technology and the economy need the improvement of IP systems and make IP protection effective, including perfecting the remedies which are essential to the running of modern IP system. Otherwise, one nation, one region will be difficult in absorbing more investment, and the key innovations will diminish there. For example, after the entry of WTO, China has strengthened IP protection greatly as to harmonize with the international trend and obey the TRIPS agreement rules, as well as to promote domestic technology and the economy more efficiently. These measures have resulted in a great increase of patent applications and trademark applications, which are both from abroad and from China, filed in the CIPO and the Trademark Office. This tells us that actually most corporations, including transnational ones, believe in the IP enforcement in China. In undertaking these measures, the reasonable remedies against IP infringement are very important points. In one word, as discussed above, all of the nations which want to develop market economy need to improve their IP enforcement in different aspects and in different degree. Secondly, to strengthen coordination, it's necessary to learn from each other's faults for better IP enforcement to the relevant authorities of each of different countries, including legislature, administration, and judicature. More study and research of other countries' legislation and practice are imperative and at present as to create mutual understanding basis for field coordination to perfect their laws and the enforcement in this area. Actually speaking, discussion like this kind of seminar, visit study, and training as well as symposium are some of useful methods of this kind of coordination. I think it's the basis. Thirdly, to recognize the importance of ADR. ADR, Alternate Dispute Resolution, which has existed in the field of IP enforcement in both developed countries and developing ones, is looked for by a lot of IP owners. With the increasing cost of litigation in some jurisdictions and the increasing uncertainty in others, therefore, when looking for remedies against IP infringement as efficient as possible, sufficient attention should be given to every possible way, including IDR, especially administrative channel, which is usually efficient and effective way for enforcing IPR. So, for ADR situation in China, you can search in the web of State Intellectual Property Office, SIPO, SIPO. You can find the recent news and information. Thank you, everyone, for your attention. Thank you.